Hello and welcome to today's Privacy Law Seminar. As we meet here in Sydney, we pay our respects to the traditional owners of these lands, the Gadigal people of the Eora Nation, and to their elders past, present and emerging. My name is Olga Ganopolsky. I have the privilege of chairing the Privacy Law Committee of the Business Law section of the Law Council of Australia. Welcome to members of the profession, some 400 participants from all parts of the profession, in-house, private practice, government and the private sector. Thank you and welcome to the Privacy Committee members who have been instrumental in putting together this seminar, and of course my colleagues at Macquarie who have made it possible to host this seminar in what can only be described as interesting times as we move so many of our get-together seminars and way we communicate to be conducted virtually. On the question of virtually, the usual housekeeping rules will apply. We will have our discussion in our seminar and we'll ask the participants to hold their questions until the end and remain on mute until that time. Privacy. In issuing the penalty notice for £20 million against British Airways, the Information Commissioner's Office in the UK emphasised that when organisations make poor decisions around people's personal data, that can have real impact on people's lives. And the law gives rights and creates obligations to support the protection of people's rights and their privacy. This sentiment is directly echoed by the community. In fact, the 2000 community attitude survey conducted by the OIC expressly found that the privacy remains a major concern for 70% of Australians, and almost 9 out of 10 want more choice and control over the way that their personal information is handled. Today, our seminar will look at key developments in privacy law, key priorities as set by the regulator, and the future of privacy law. What better way to discuss these issues than with our own Information and Privacy Commissioner, Angelene Falk. The Commissioner leads the OIC both here in Australia and of course at the international stage. As many of you will know, that privacy and data is a global game. This year, the Commissioner has set, and the Commissioner's Office has set, 4 main priorities. The first one is the online platform and social media and the high privacy impact of information technologies that we use every day. The second priority is the security of personal information, particularly in the finance and health sectors in relation to the failure to take reasonable steps to protect personal information where risks and mitigations have already been outlined by the OIC. The third priority is the implementation of the consumer data right. And fourth, as you would expect, new personal information handling practices that emerge from the COVID-19 crisis and the pandemic, and the COVID Safe app and the way that these apps are being used in the community and more broadly. So welcome. Today we have an opportunity to ask a few questions, and so my role will be to lead the discussion, but really hand the floor to the Commissioner to discuss some of the ways that the Commissioner approaches many of the issues that practitioners and participants in this heavily debated space participate. So the first question we wanted to explore is, how are these 4 priorities set?
Oh, thank you, Olga, and thank you to the Law Council for having me here today. And I'm just so pleased that we have such a great turnout on the line for this seminar today. And it just indicates, I think, the interest of practitioners, but also the broader interest in the community on these very important privacy and data protection issues. So in terms of the regulatory priorities of my office, if I can start from the premise of the role of my office. So our function is to promote and protect the personal information of Australians and also their access to information rights. And our vision is a country where citizens have trust and confidence in the handling of their personal information. And so we've articulated these 4 regulatory priorities in an effort to reach that goal. And if I think about how we arrived at those, Olga, the journey over the last 2 years has been a rich one for all of us. If I think about when I came into this position in in March of 2018 in the acting role and then into the formal position in August of that year, I think the landscape has just fundamentally changed for us as a country, and I think globally. And some of the key issues that arose then, which I think have really led to where we are now, are the Notifiable Data Breaches Scheme. So that came into operation in February 2018. And that was quickly followed by the world realisation of the issues around Cambridge Analytica and Facebook, and I opened an investigation into that matter. We moved on quickly to celebrate 30 years of the Privacy Act, and just to reflect on the huge changes that have occurred during those 3 decades, with bringing the Act not only to cover the public sector, but through to the private sector as well. And then, of course, on the 25th of May 2018, the GDPR. And again, what I think that did was it brought data protection globally right in front of every business practitioner in Australia. That really framed then what was to come, and that was the opt-out time for My Health Record, and people remember that really engaged community debate about that, and citizens' views about the control of their health information. And then following that, we had the ACCC's Digital Platforms Inquiry. And I think that, coupled with the Cambridge Analytica matter, really unlifted the veil on the data handling practices in the online environment. In 2019, we moved into a year where government made some commitments to provide greater funding to my office for the online environment, and also to create legislation for a binding code to regulate the online environment, infringement notices, and significantly to increase penalties that I'm able to seek from the Federal Court to bring them into line with the ACCC consumer penalties of $10 million. So they were really significant. And the ACCC's inquiry, of which we heavily engaged, then led to recommendations for a review of the Privacy Act, which of course is where we are now, with the terms of reference just announced at the end of the month. So all of that environment has really informed the regulatory priorities of my office. So starting off the first one, in terms of the online environment, we're seeking to address issues that will shift the regulated community to give individuals greater choice and control over the handling of their personal information, but also to incentivise online platforms to build in accountability measures to ensure that the burden is not simply placed on the shoulders of individuals, but the processes, the systems embed privacy by design. And you'll see that through the regulatory actions that I've taken. In terms of success in that area, we do want to see a change in practice on those fundamental issues around choice and control and strong accountability. And we're coupling that with our work we're doing with government on developing law for a binding code for social media and the online environment. And that'll give greater particularity around notice, around requirements for consent, and really assist individuals to understand their information flows. At the same time, success is also achieved through regulatory cooperation. So we've got strong MOU arrangements with the ACCC and also work with the E-Safety Commissioner, but then also globally. The second regulatory priority around security. So the Notifiable Data Breaches Scheme has brought to the fore for us all the risks that are inherent with coalescing large amounts of personal information. As people will know, the scheme requires businesses to ensure they've got strong, reasonable steps in place to protect personal information, but also an ability to respond should a breach occur and to report it, to enable individuals to take action to mitigate their own harm, but also to provide that accountability through to my office as the regulator. So our regulatory priority is about building on the educative work that we've already done. I've released a number of reports since the scheme's operation in February 2018, and those reports detail the causes of data breaches. So we know that the biggest cause is, of course, cyber, but inherent in that is phishing, ransomware attacks, so that utilisation of individuals to infiltrate systems. So what we see is that the human factor is really central in this area. So the regulatory action is about saying, we've told the regulated community really clearly that this is the cause. We've given clear guidance on the areas of concern, and now then there needs to be put in place those safeguards, whether they be technological, multi-factor authentication, the people in terms of the training, ensuring individuals understand phishing emails and so on, but also the processes that support people in the workplace. The third regulatory priority is about the consumer data right. So practitioners will be familiar with the notion of access to personal information, a right that's been embodied in the Act since its inception. In the GDPR, there's, of course, the data portability right, but in Australia, I think it's really been taken to another level, and that's through the development of the closed system, through the work of the ACCC and the OAIC in developing up secure safeguards and a system for the banking industry to engage, for data to flow for the benefit of consumers. So at its heart, it's about consumers being able to see if they can get a better deal, and to do that in a way that they have control over their data. And it's really important that those safeguards are enforced, and what my office will be doing is not only handling individual complaints, but also conducting a series of audits and looking at the governance in place that ensures that the participants in the system are really adhering to those privacy and security safeguards. And the last one, the issues that are arising in COVID-19 and the pandemic, of course, was something that we couldn't have envisaged. It has, though, required my office to pivot and to be very agile and to respond to these issues as they've emerged. Very early in the pandemic, we saw both business and government wanting to do the right thing to ensure that they were both preventing and managing the spread of COVID-19 and wanting to use personal information as a means to achieve that end. What we've sought to do as an office is to provide good guidance, best practice guidance to facilitate that, but also to work really constructively to ensure the right safeguards are in place in this environment. The COVID Safe app resulted in really strong legislative protections and provides a very strong precedent for the kinds of protections that I think Australians expect when they're being asked to use their information in ways that we wouldn't have expected even 8 months ago. So my office is again conducting a series of audits of the COVID Safe app right through the information life cycle. And at the same time, of course, individuals can make complaints. We haven't received any complaints, and we've done a lot of work with peak bodies to ensure they understand that the COVID Safe app is voluntary, that it can only be used for contact tracing purposes and so on. So that's the 4 regulatory priorities, and in all of that, I overlay the fundamental requirement of collaboration and cooperation. So both domestically through the other regulators that intersect with my jurisdiction, but the work that we do globally to ensure that we're being informed by the strength and wisdom of my colleagues internationally.
Can I just take you back to a couple of things you said
Of course.
In outlining your priorities? And maybe we start with the consumer data rights.
Yes.
You obviously made the connection to the European rights of portability, but also the work that's being done with the ACCC in administering. Can you elaborate for us what that administration will look like, given that it's a co-regulatory scheme, and given the fact that a lot of attention has been put on protection of privacy and the safeguards and the interaction of the safeguards with the more generic privacy practices that many of the practitioners here would regularly give advice on.
Yes, this is a great example of how data protection is no longer just a Privacy Act concern, that protecting personal information now requires the intersection of a number of laws. So the Consumer Protection Law, as well as the Privacy Law, regulates the whole ecosystem in terms of consumer data right. But the privacy safeguards are in the consumer law, and I've got responsibilities for enforcing those. But the ACCC and my office have entered into an MOU arrangement, but we've also published a joint regulatory action policy. So our enforcement approach is very transparent and clear to the regulated community, and we each have specific obligations to undertake, and we'll do that in a way that's consultative and takes account of also the limited resources of business and the best way to engage business on ensuring compliance.
Thank you. Jumping ahead to the COVID app that you've outlined as well, the salient thing, I think, from the experience, certainly looking at it from a law counsel perspective and the submissions that were made about the development of the app and the legal protections, is really the fact that from day one, this was about trust and how the legal mechanisms would support that. But equally, it was about probably the most sensitive of the data sets that one could possibly hold, the health information. And the uptake of the app has been, very, very strong. Do you want to elaborate a little bit on the element that the trust that people had in the system and the passage of the protections that are now, as you say, form part of the Privacy Act?
Yes, a great question. And that whole experience from my perspective has been a great model, and there's many lessons to be learned from it. So ensuring community trust and confidence was critical to the success of that application. And when we're asking the community to move at great speed and to interact with new technologies in new ways, we do need to ensure that they have the trust and confidence to do so. So the first point that I would make is that under the Privacy Act, there's a code that applies specifically to government agencies, the Australian Government Agencies Code, and that requires a privacy impact assessment to be undertaken where there's a high privacy risk project. So the Department of Health commissioned such a assessment, and my office was engaged in advising and guiding in that process. And I think the very positive aspect of that was that all of the recommendations were adopted by government, and particularly this recommendation around the legislative protection. So my view was that legislative protection would provide the ultimate safeguard. And we really saw Parliament making a decision that this was going to underpin the trust and confidence of Australians. And we saw the strongest privacy protective legislation enacted that the Parliament has ever seen. So I think there's a lot to learn from that. And particularly those fundamental principles that should inform all development of legislation that has an impact on privacy, and that is the proportionality issue. So ensuring that any intrusion on privacy is necessary, reasonable and proportionate to achieve a legitimate public policy objective, and that there's an evidence base around that. And the proportionality was achieved in this particular context by those very strong safeguards, which make it a criminal offence to deal with the information in an unauthorised way, as well as the ability for my office to handle complaints.
And the coercion, that's a very strong prohibition against coercing people to use the information. I think that was a very, very strongly...
So that it had to be voluntary in order to have the community buy-in and trust and confidence, that the voluntary nature of it was really fundamental. And I think that there were lessons learned from the My Health record, when there was subsequent legislation introduced to limit secondary uses of that information based on community concern. And so in this situation, it was made very clear that it was only to do one job and one purpose, and the information could only be used in that way.
And I think that was very loud and clear and consistent, both from the sort of the early stages of the development to its ultimate passage. Can I jump ahead again and focus on the mandatory breach scheme and how that reporting regime is working. You mentioned before that it was working well and it's given a great deal of transparency and lessons learned. But you also mentioned that there were some particular expectations that have been created as a result of, now 2 years on, of looking at what the reportability is telling us. Do you want to elaborate on what are some of those expectations and what can we expect to see, both sort of in the practical realm that some of the practitioners would be advising on, but equally as we move into the law reform where clearly this will be, once again, open for discussion?
Yes. So in terms of the issues that I think practitioners should be alive to, I would encourage everyone to look at the 6 monthly reports that my office has released, and we call out some of not only the causes of the breaches that I've mentioned in terms of cyber intrusion, but also human error, but also what we're seeing in a more granular way around some areas for concern. So one area that is of great concern is quite a significant increase in data breaches as a result of businesses filing personal information in email systems and then not having multi-factor authentication for access. So the phishing email comes in, the credentials are entered into the inbox, and then that information is exfiltrated. So I've called that out really clearly. So my strong recommendation is, from a risk management perspective, that we need to go back to the basics in terms of information management. And it goes back to ensuring you've got a privacy management plan in place, that you know your data holdings, that you have good, strong processes in place for how you keep the data, and that you have put the right protections around it. So that's the first thing. The second is in terms of the running of the scheme itself and the obligations that it imposes. So the objective of the scheme is twofold. The first is to allow that timely notification to individuals so that they can take measures themselves, change their passwords, contact their bank, get a new passport, etc. But also it's about ensuring that the organisation itself is transparent with the regulator. It has identified the causes. It's put in place steps to ensure that the issue doesn't occur again. What we're seeing is in some cases some delay in that process occurring. So in many cases there might be an intrusion that occurs. There might be a reasonable suspicion to believe that there might have been an eligible data breach that's reportable. Under the law, there is a period of time to conduct an expeditious assessment to form a view as to whether or not to report. But we think that really should occur within 30 days. It should only really be in extreme circumstances where that's not possible. And I'd really encourage good record keeping and reasons for why that delay might need to occur. And once the reasonable belief has been formed, notification should occur, and that notification should equip an individual to take steps to mitigate their harm. So we've seen some very good examples where there's great particularity around steps individuals can take. There might be a hotline set up for information, as well as assistance from the business to help the individual to recreate their identity or to mitigate their loss. And I think that's a reasonable approach to take. Businesses are holding this data as trusted custodians, and if a data breach occurs under their watch, then they should make amends and rectify that. So that's where I'd like the focus to be. My message really is in terms of those reasonable security steps that I called out around the training, the processes and the security systems themselves. And where there are significant, if you're leaving the keys under the doormat, then you can expect the regulator to come knocking on the door.
We hear you. We've got some questions coming in thick and fast, but as we said, we're going to leave them for later. But it's wonderful to see we have so much engagement from our participants. Before we launch into those questions, and I can see already some themes emerging from some of the comments you've made, Commissioner, can I just quickly turn your attention to cross-border transfers? Because obviously most organisations transfer information, not just outside Australia, but that information circles across borders. And obviously we've seen a lot of activity, particularly in the EU. Just want to hear your perspectives on what's happening and the role that your office is playing in putting some clarity around what is actually a very complex area.
Yes. So, of course, data knows no borders. My office is very focused on working in the global area to ensure both the sharing of information for regulators, cross-border enforcement, but also to look at our laws and frameworks to ensure interoperability. So we see that that's critical both from mitigating the kind of regulatory friction that might occur for business, but also to ensure that Australians' data is protected wherever it flows and the commensurate nature of those protections. So if I can give a couple of examples of the work that we're doing in that global arena. Well, first of all, I'm on the Global Privacy Assembly and member of that executive committee, which has as one of its objectives to ensure that we have this intersection and interoperability with laws and frameworks. We also co-chair a consumer group that looks at both the intersection of data protection and consumer protection in a global way. And we can see, of course, the way in which globally consumer protection cases are being taken that also intersect with data protection, both in the EU, but also in the US. But in terms of the free flow of information throughout the global economy, it's really critical that there's the opportunity and the ability to do that cross-border enforcement. So I have undertaken a co-regulatory approach in relation to the matter of Clearview, where we're looking into allegations of screen scraping of considerable billions of people's data internationally and in Australia for a particular business model. And that investigation is occurring with the UK ICO. So that enables both the business to have a seamless interaction with regulators globally, but also for us to join up in terms of our intelligence and regulatory approach. There's also, of course, been recent activity in terms of the EU and US data transfers, and practitioners are probably aware of the Schrems 2 case. So that, of course, has made data transfers from the EU to the US under the Privacy Shield mechanism invalid, and has also called into question how standard contractual clauses are implemented in cross-border data flows. I think it's too soon to tell what the implications of that might be for Australia, but I do note that the European Data Protection Board released guidance only last night or overnight. I woke to it this morning, which starts to unpack what some of the additional measures might need to be considered to supplement or embed within standard contractual clauses. And they're things that we're all very familiar with from what my quick reading of it. It's around organisational or technical safeguards and contractual safeguards. Again, it takes us back to our fundamental principles around knowing the data holdings, mapping the data flow, doing the privacy impact assessment in terms of the risks in data transfers. The European Data Protection Supervisor has now coined another methodology building on that called a transfer impact assessment. And each entity in the EU, public sector, needs to undertake that and map their data flows. So I think where this is going to come to light, and for practitioners a real opportunity to engage on these issues, is in the Privacy Act review. One of the things that we'll be looking at is the Transporter Data Flow Principle, Australian Privacy Principle 8 in our domestic law, and looking at whether that remains fit for purpose. We think it embodies a good principle of accountability with ensuring that the entity in Australia that transfers the data remains responsible for that data, and that gives individuals clear enforceability rights.
Well, we certainly look forward to that discussion, because I'm absolutely positive that many of the participants in today's seminar, particularly members of the legal profession and the privacy profession, are busily drafting all sorts of clauses and looking at all sorts of data flows. So they're very important technical issues as well as practical measures in terms of controls. And you mentioned something really important, that obviously our regime for cross-border transfers is different to what we have in GDPR and the European framework. But still, a lot of Australian companies do use model clauses as a benchmark and a high watermark. So this is a very topical area. So really appreciate the additional guidance. Thank you. Jumping onto law reform, we were obviously at a really, really special time, in that this is an opportunity to really recast the Act and look at the measures that we want to take from a legal perspective in order to get comfortable with the digital economy and everything that goes with it, both the good and the risks. The scope and the terms of reference for the review are actually very broad and very generous. They jump from, as you would know, from a number of things, from the scope and application of the Privacy Act itself, to whether the Privacy Act protects adequately the information, and what should be any additional rights that individuals might have under the regime. So really, this is going to be a very thorough and topical review. I know we're still in the very early stages and everyone's busily writing various submissions and thinking about their approaches, but were there any specific things that you wanted to call out in terms of the role that your office is playing in the review as obviously the key regulator?
Yes, thank you. What an opportunity that we have, and really it's a once in a decade opportunity, and it has been that confluence of circumstances, both globally and domestically, that have led us to this place where we have the review on foot. It's really exciting from my perspective, because it provides an opportunity for Australia to be world leading in data protection. We have the advantage of the GDPR having been in place for 2 years, and we can learn from the collective wisdom of what was then the 28 member states who negotiated that arrangement. We also have the Californian law and other emerging laws internationally that we can draw upon. And I think it's important that we come at this from the principle of, as I said, global interoperability, seeing how our laws can intersect, but at the same time, adapt them for the Australian context. So my office's role is to provide advice on the need for legislative amendment in the interests of the protection of personal information. So we'll be heavily engaged in the review, and I would encourage practitioners with a keen interest in this area to read what's quite an extensive issues paper from the Attorney General's Department, who is running this review, and to engage with its scope and depth and breadth. From my perspective, it's also an opportunity to think about what is it that we think privacy laws should address into the future. The current objects of the Act focus on the fact that privacy is a human right, that of course at the same time there needs to be the free flow of information and personal information protected in that context. I think there's also an opportunity for us to reflect the public interest that's in privacy. We've had a real focus on the individual rights of privacy, yes. But for all of us, the protection of our health information means that we seek health services, and of course that has a societal benefit. At the same time, I want to bring a lens to this that looks at what is the harm that can be occasioned by interferences with privacy, and an emphasis on how to prevent that harm. We saw in the UK that there was a white paper on online harms, digital harms, which recommended a duty of care in that context. It removed data protection from that consideration. But subsequently, one of the parliamentary committees in the UK made some comments around similar concepts being relevant in a data protection area. And I think that's right. So I think we need to think about ensuring that we've got a framework that has reasonable, fair and reasonable practices of handling personal information embodied within its framework. And if we get that right, then the other issues around how we achieve consent really come from that first principle of, is this a fair and reasonable way of handling personal information? The other aspect is to ensure that we get those accountability measures right in the legislative framework. So there's 4 areas where I've said publicly I think we need to focus. I've mentioned the global interoperability, but the other is making sure that we do get this notion of privacy self-management right with choice and consent and control. And I see a comment up there around how can consent operate, and we have such complexity of information flows. So I think we do need to think about, where can consent really be meaningful? How can it be fully informed and freely given? And confine it to those situations where in fact it legally and lawfully has the right work to do. In terms of the third issue, it's around organisational accountability and making sure that we build in the organisational responsibilities. So a simple example of that is, I think we can do more with Australian Privacy Principle 1 to call out a bit more expressly some of the expectations to take a privacy by design and by default approach, to have a privacy officer, so drawing on some of the GDPR there. I'm also interested in the term of reference that talks about whether or not we should have a certification scheme.
Yes.
And again, that's a strong accountability mechanism to hold one's organisation out as attaining certain privacy standards. And that's a wonderful mechanism, I think, potentially for consumers to help inform them of their choices. And I'd like to see practitioners engaging with that. And I'm also thinking about domestic models where we've seen this starting to work, and the consumer data right is one such area where entities have to be accredited before they can participate in the scheme. Therefore, if you like, having a certification that their security is sufficient. And the final area for review, and I should say that there's a lot in those 3 points I've made, and we could talk for hours about it, Olga. But the last one is around making sure the regulator has the right tools to enforce. So I think that we've got a good toolkit, but there's also room for enhancement. I'd like to see greater ability to issue not only orders to have practices changed, but also look at issues like infringement notices. So looking at some of those other tools that occur in the consumer protection regime, for instance.
It's interesting how often the example of, we start with human rights and it moves to consumer protections and expectations and the conversations about daily interactions that people have with services and data. One of the things that your office has done for now, I think 30 years, is to conduct a longitudinal study of consumer expectations of privacy. And we mentioned that earlier when we first opened the seminar, but obviously you had a survey completed in the course of this year, the 2020 survey. Are there any consumer or public style expectations that are really of interest for the law reform process, and is there anything particularly of note? Because there were some very, very important findings. Some are slightly inconsistent in terms of people caring about their privacy, but not necessarily reading the privacy collateral that's presented. What are some of the things arising out of the survey that may inform the law reform process, and how are we thinking about that?
The surveys are a really rich resource, and I commend it to listeners to have a look at it. And there's a summary document on our website. We've conducted this survey in one form or another for many, many years, and it continues to show that privacy, of course, is a key concern for Australians, with 70% of people saying that it's a major concern. I think the really interesting statistics are around 80% of people wanting more choice and control over their information. And then if you drill into that a little bit more, there's specific aspects of the survey that we conducted in terms of children's privacy. Right. And so we find that your parents are more concerned about the privacy of their children than their own privacy, and a real desire to have defaults, right, if you like, set to off. So not having geolocation tracking on by default. Right. So that's a rich source of data to inform what this issue about choice and control should look like. The other is that Australians are saying that they do want government to do more to protect their personal information, and a very strong support for some of the exempt bodies that are currently not covered by privacy law to be brought into the Act. So that includes small businesses, political parties, as well as issues around employee records exemptions. Yes. So they want the coverage to be holistic. They're also interested in other data protection rights that appertain, for instance, to artificial intelligence and automated decision making. They want to have direct access to the courts, and that's a term of reference. Yes, it is. Indeed. That's it. And a strong support for an additional rights-based framework. One of the really telling statistics for me, and it goes back to the point that I made around this notion of harm, is that 80% of Australians consider a use of their data for a purpose that they were not expecting to be a misuse. And they also want to have their personal information protected so it doesn't result into harm to them individually. So again, when we talk about harm, what does that look like? It can be targeted advertising that could result in differential pricing. It could be discrimination in terms of access to services. It could be the way in which the ad tech regulations work, such that gambling advertisements are provided to someone who's at risk, and so on. So the spectrum is quite large. And then if we think of it in terms of data breaches, harms on the nature of the information. Was it your health information? Was it identity information? But fundamentally, I think that notion of ensuring that the data protection regime can prevent harm, mitigate harm, is one that we should look at very closely, and has really strong support through the survey.
It's interesting how holistic it is, that people, even in the context of replying to a survey, really do think about it in a life cycle way, and really do think about the data living through various stages, including inside organisations. So that use case is very, very interesting.
I think we have a community that's very engaged on data protection. I've certainly seen that over the last 2 years, and I think it is also a result of that intersection with other regulators that I mentioned, the work of ACCC on scams, the work of the E-Safety Commissioner together with my office, and also the work that occurs with the Australian Centre for Cyber Security. So the community awareness and engagement is very high.
And they seem to cross-pollinate each other in terms of how they think about respective issues. Speaking of cross-pollination, can we cast our mind to other jurisdictions? So we've kind of spoken about the local inputs from the Australian community. What about some of the international influences? And obviously GDPR looms large. You've mentioned California. What are some of the influences from overseas on the way we think about law reform and what we'd like to see or not perhaps like to see?
As I said, I think that both of those laws give us an opportunity to take from them what we think will enhance the Australian framework. From the GDPR, I think the definition of personal information is one that we can look to. Practitioners will be aware of the Grub and Telstra decision, and some of the technical issues that arise in terms of whether information is about a reasonably identifiable individual, whereas the language of relates to is used in the consumer data right domestically,
Yes.
but also in the GDPR. Similarly, making it clear that technical data is embodied within the definition of personal information. And by that, of course, we're talking about IP addresses and so on. So that's a great starting point. And I think having that commonality of interpretation will assist business and also assist consumers in terms of global protection of their information. The other is looking at some of those individual rights-based protections that are embodied in the GDPR. So I mentioned artificial intelligence and the right to have human intervention in automated decisions. So I think that's one that should be looked at carefully with the review. The other is the right to object to data processing, and that was a recommendation that came out of the ACCC's review, as well as rights to deletion. Now, the right to deletion, I think, is one of the complex rights, and really value practitioners' input on all of these issues, of course. But I think the deletion one is one where you get that real intersection of competing rights and interests, both the right to privacy, but also freedom of speech, and at the same time, there's broader issues about where the public interest lies, and also issues that I know in the e-safety realm are of concern in terms of keeping evidence and so on for unlawful activity.
Yes.
So I think there's some of the critical individual rights. And in terms of California, one of the interesting aspects of that law is the way in which they construct their notice requirements. And I'd like us to be looking at not only that we have clear, intelligible, succinct notifications, but also that we have some common lexicon that is being used so that consumers start to recognise certain symbols, certain phrases to indicate the way in which their information will be handled, and therefore helping to empower individuals to make those choices.
It's interesting that much of our discussion was obviously about the privacy regime in the Australian context, which has traditionally been very principles-based, particularly in the generic landscape, leaving aside obviously credit reporting and some of the specific black letter law regimes. A lot of the examples that are emerging are pointing us towards a more prescriptive regime, or at least a regime where the criteria for how decisions are made are going to be described and articulated in legislation. Is that a passing trend, or is that an area of focus or thinking that's emerging?
It's a good point. It's a good pick-up, Olga. I think that where we're at is that we have a principles-based law that I think holds us in good stead in terms of being applicable right across the economy and addressing those challenges. But fundamentally, it also allows organisations to take a risk-based approach to regulation, and it allows the regulator to take a risk-based approach to enforcement. So I think that starting proposition should remain. That would be my view.
Okay.
But I think that there's an opportunity to give greater clarity in the code-making powers that exist in the Privacy Act to underpin that. So I mentioned the Australian Government Agencies Code.
Yes.
There'll also be an online social media code. Those provisions, I think, could be streamlined and work in a more effective way. I also think there's a role for guidance. At the moment, my guidance is advisory.
Yes.
Under the FOI Act, which I also regulate, there's a legislative requirement for agencies to have regard to the guidance. So I think there's an opportunity to elevate some of that as well. So we need the certainty for businesses. They need to know where the regulator considers bright lines to exist, but at the same time, we need the flexibility to take that risk-based approach.
No, that's a very good way of summarising it. I can see some wonderful questions beam up from our participants, and one actually relates directly to the discussion we just had about GDPR and overseas influences, and it seems to ask whether there is any appetite to apply for adequacy. Is that something you can address as part of this conversation, or is it too early to discuss while we're still waiting for the issues paper?
Yeah, so for those who mightn't be as familiar, we talked about the data transfers from the EU to other countries. And one mechanism where that can occur is through the EU recognising, say, Australia's law as being having adequate or commensurate protections. There's only 12 countries in the world that have AD status. So it's a mechanism that's lesser used than, say, the standard clauses mechanism. We recently saw Japan obtain adequacy, and they were the first, I think, to my knowledge, country to actually also have reciprocal adequacy and ask the EU to demonstrate their adequacy in return, which was an interesting development. In 2001, Australia did get an opinion from what was then the Article 29 working group in the EU on whether Australia's law would be adequate, and that opinion expressed some reservations in principle around the exemptions that I've outlined, particularly the small business exemption. We're one of the few countries in the world to have that kind of an exemption in place. Australia hasn't sought adequacy since that time. Rather, the emphasis has been on the cross-border privacy rules framework, and Australia has signed on to that, and work's being done. So ultimately, that issue is one for government to make, but I think it is an opportunity if practitioners have views around this to put that into the privacy review. I'd encourage them to do so.
I think it might well be topical, because certainly what we're seeing separately to the privacy regime in Australia, the GDPR is such a strong influence for regional legal development, and we're certainly seeing jurisdictions like India create new legal framework for data protection, Singapore updating its regime. But one of the things that's emerging, and in fact it's picked up in a question here, is that in addition to creating these environments, there's a strong force to data localization. And the example that one of the questions from the participants notes is India, China, and Pakistan. Any thoughts about the interplay of localization versus free flow of data and some of the privacy things that you have already eloquently discussed?
So under the Australian Privacy Act, there's not a data localisation requirement. There needs to be reasonable steps in place to protect personal information. So an entity that's going to store information needs to conduct a risk assessment and decide where their information should be held. And part of that should be a consideration of, if it's to be held offshore, the laws of other countries that might impact on that risk assessment. There's a couple of exceptions. The My Health Records is one such exception where the information must be held in Australia, and also the COVID Safe app. I do think this is a topical question. I'm glad to have received it, and I would like to emphasise that requirement to conduct a risk assessment. So whilst there's not a data localisation requirement, it really should be front of mind.
Thank you. Thank you. We have quite a variety of questions, really an abundance of issues. If you don't mind, there's one here that is a recurring theme, and you could see it on the screen as well. So, and it relates to kind of cross-border enforcement and the risk of what the question raises as double punishment given the overlap of legislative regimes, be it local requirements like the Privacy Act, ACL, Corporations Act and so forth, and cross-border nature. Do you have a view on how enforcement works in the co-regulatory international environment?
Well, both from a domestic perspective and internationally, we need to ensure that all regulators are working in concert, and it's not unusual to have the same facts and circumstances relate to different laws and remedies that arise. So we're all familiar with that. I think one of the examples of that domestically is the Notifiable Data Breaches scheme, where we're also seeing APRA has a reporting requirement which goes beyond personal information.
Yes.
We've also seen a recent action by ASIC in terms of allegations that cybersecurity was insufficient. So we're seeing those directors' duties as well as the APRA requirements and then the Privacy Act NDB scheme come together. Of course, we have relationships with those organisations and seek to take action. My office seeks to take action that's informed by the actions of other regulators, and there might be situations where it is the right thing that there's multiple laws that need to be brought to bear on a situation. I think so long as that's done in a purposeful way, that our regime can handle that. In terms of internationally, I mentioned the work that we're doing with the UK, and previously my office conducted an investigation on the Ashley Madison matter with Canada, and then also the FTC in the US. So I think we're going to see more of that, and you will see the bringing together of intelligence, but also the bringing together and bringing to bear the laws of multiple jurisdictions. We each have to enforce our own laws, but we want to try and do that in a way that both reduces the regulatory friction and burden, but also provides protection wherever Australians' personal information flows.
No, thank you. Thank you. I'm very mindful of the fact that our wonderful hour is drawing to a close, and we still have questions coming in thick and fast. If I can pick up one more, if I have that indulgence. There is a question on the current state of surveillance laws in the context of the developments of how technology uses and collects data. Is that something we can elaborate on, or is that another one for law reform?
Surveillance laws?
Yes, surveillance laws in the context of the developments. Do you have a current view?
Well, surveillance laws across the country, there are many at the state level and also at the Commonwealth level. If we talk about interception laws, but also other laws that operate at the state, and there's been law reform commissions that have looked into this issue. My office has a role in terms of the telecommunications legislation and retained data, which of course is deemed to be personal information. We continue to conduct assessments and inspections in relation to that. I suppose just as a general point about surveillance laws and their development, again, my advice on any of those laws comes from that position of needing to be necessary, reasonable and proportionate.
Thank you. Thank you. And yes, these will remain very topical issues. When we opened the seminar today, we said we're going to be talking about a number of things. And I think we really did that because the conversation, both in the course of our discussion, but also in terms of the questions, really moved us from the consumer-facing issues to the human rights-facing issues to the work that's done at the international and local level, and privacy being such a powerful both idea but also a set of legal rights and obligations. And we're very grateful to you for making it come alive, both in the way that the law works now, but equally, as you can tell from the discussion and the numerous questions about what the law of the future holds for us. For those of you that are still on the line as we wrap up, there are ample opportunities to be involved in the law reform process. As the Commissioner said, the issues paper was issued at the end of October, the 30th of October, and the discussion around those issues finishes on the 29th of November, so plenty of time to get involved. And I think 2021 will definitely be a privacy year where we will regroup on the discussion paper that will follow from the issues paper, and of course the legislative process kicking in the course of 2021. So we're very grateful for your time, for your insight, and really the thought leadership that you're showing around really complex questions of both law and policy and practice when it comes to the technology that we use every day and the way that we interact every day, particularly now that we're enjoying ourselves with the benefits of most things virtual. So thank you very much to you. Thank you very much for the team for making this come together in a virtual sense. And of course, again, thank you to all of the practitioners who have joined us to contribute to what is a really live question, both of law and policy. Thank you very much.
Thank you. Thank you for the opportunity. I look forward to seeing you again, Olga.
Thank you.